If I got hoed by a huge like hospital bill that I cannot pay, right? Then my credit, right? Because once it hits collections, 90 days, right? Not making a payment hits collections and everything, your credit down the water, right? Now getting housing is harder, right? Because there's credit checks. Getting a job is more harder, right? Because they do credit checks in case if you have excessive debt, right? Because those are certain liabilities that certain companies, especially in certain industries, avoid hiring people to have. Right now, like I can't afford to like start funding certain things. Like if I wanted to start a business and trying to get like a initial credit loan, or trying to like get a new a car or something, right? Like what if my car my car blows up, right? I need a new car, right? I'm not about to finance it if I got a hospital bill that went into collections for damn sure, unless I'm going to pay an outrageous interest rate if I find one that actually gives it to me.
We've never, ever, ever needed a Supreme Court to tell us that the president has criminal immunity from that. The idea that we needed this decision today to spell that.
Well, I would sit there and argue that, like, true, we didn't need the Supreme Court, we didn't need the court system, period, to actually make that clear that the president should enjoy immunity. The problem is, it's just that because the law technically, well, prior to then, right, because it technically could be possible. All right, we're back. So what we're going to do now, let me save my thing here. We'll close that. And yeah, look at my colors. What I'm gonna want to do is I'm going to want to. Yeah, I guess I can leave those two out. Close tabs to the right. Pop her open. Bring you down. Bring you over here. And then I'm gonna open up my decks here. This is, so we don't try not to get copyrighted whenever possible. Okay. Gotta, significantly transform the content at hand. So my go-to here is playing Mindustry, which you won't see me play quite yet, or a lot of quite yet. I'm just going to use it to just let it build up materials while I sit there and, oh yeah, because I was getting ready to what's the word I'm looking for? Yeah, I was getting ready to make new pathways. Maybe I could tighten up this one before then I go to a new map or whatever. So okay, cool. So we're actually out. Don't need no more titanium, and you don't need no more of that. Don't need no more metal glass, so that's cool. Am I really like capped out? I'm capped on. Oh, I'm capped on everything but this stuff here. Okay, cool. Yeah, let's go ahead and let that. Then as soon as that hits 9, oh, and that too. So this and this. Yeah, and then I don't have any silicon, so we know the silicon can go do its thing. So all right, we're good now. So let's go ahead now. Let's start this video while I eats me some cereal. Yeah, we'll look at it like that.
Let's take this to its logical conclusion.
Okay, let's
Using
do
the
this.
model
Yes.
that we have set up
Yes.
under the Supreme Court majority.
Yes.
The president does speak to the military. The military does control SEAL Team 6.
I know he is not actually on the thing, but he's saying it like as if like he's actually sitting there talking with it directly. That's funny. Okay. I also need to like not be eating, or like I don't want you to hear me crunching, so I'm gonna have my mic muted and I'm gonna try to remember to unmute it when I want to speak, and hopefully not speak and not be able to hear me. So mute my mic and then eat cereal, and we can go ahead and get to it.
So that in and of itself is inside the official act. However, the president ordering them to do something blatantly illegal, like murder his political opponent, prosecution of that crime would certainly overcome any presumptive immunity the president has in ordering his political rival to be killed.
He doesn't understand the ruling. He's making the mistake that to overcome the presumptive immunity, you have to show that the action was really bad. That's not the test. The test for overcoming presumptive immunity has nothing to do with how bad the act is. The test has to do with...
Then that would threaten the constitutional order.
Whoa! Yes! Yes! Holy sh... These are my full takes on the recent Supreme Court case that was just ruled on July 1st, in which Donald Trump is bringing a case before the Supreme Court seeking some forms of immunity from criminal prosecution for at least things that he considered to be official acts of him as the president. That's what his counsel was arguing in front of the Supreme Court. A lot of people are talking about this, probably people who either haven't read it or don't understand it or have, some agenda that they're interested in pushing about it. But regardless, here's my reading of it, of which we've spent the last 3 days painfully going over the entire decision. Chief Justice John Roberts, writing their majority opinion, argues that the president has 3 different types of actions that he can take and then creates a novel ruling about the types of criminal immunity that would apply to the president based on the kind of action that he's taken. For these actions and for the criminal immunity that's been granted for these actions, this is a new thing that has never been done in the history of the United States, as far as I'm aware, as far as anybody else pointed out, for basically any citizen ever at any point in time. The idea that there would be absolute criminal immunity for some action has never been discussed in the history of the United States, not for the president or anybody else. Roberts is going to make a ton of citations to a case relating to, I think it's Nixon v. Fitzgerald or Fitzgerald v. Nixon, that has to do with suing the president for having an airline official being fired, basically. But despite the fact that Roberts will cite to this case over and over and over again, that case had to deal with civil immunity, meaning that a president can't be sued for civil damages. It had nothing to do with criminal immunity, and every mention of criminal immunity in that case seems to be judges all saying, like, obviously this wouldn't apply to criminal stuff as well. We're only talking about preventing the president from being sued for, by private citizens, civil matters, right? So the 3 buckets that John Roberts basically groups actions into we have core powers, which are actions that, and he's borrowing language here from a prior case, he calls these conclusive and preclusive actions that only the president can perform. Any action that's taken here is given absolute immunity. These actions are not only beyond judicial review, none of these acts are able to be cited or referenced in any other criminal matter as evidence or otherwise. So if Donald Trump is performing some action that we consider to be conclusively and preclusively within his role, so for instance, conversations between him and his officers, like the heads of his departments, these things would be beyond all criminal review. You can't probe into them. You can't cite them for anything else. So for instance, let's say that we knew that Trump said, I'm going to fire you unless you do XYZ criminal act. Let's say that I can't criminally indict him for that. I can't even use that as evidence towards another crime, which is going to be relevant for obviously for Trump's criminal prosecutions. But the core powers here that are conclusive and preclusive to the office of the presidency, Roberts has said that these are given absolute immunity from all criminal prosecution. I think if you go to destiny.gg/notes, I think you can get all my notes that I publish for things, and you can go and read. I've got larger quotes from the decision here, and I think I even have the decision in my document somewhere. But the second bucket that he's got, he calls these things official acts. So official acts are actions that the president takes up, that are up to the outer perimeter of all of the things that a president can do, as long as it relates to the effective discharge of a president's powers. So any action that is declared to be even in the outer perimeter of what a president might do as an official act are given presumptive immunity in order to protect the president's ability to execute the duties of his office fearlessly and fairly. Roberts will speak a lot about how we need an energetic and vigorous executive, and he will cite the Federalist Papers when he says this over and over again. I will say, however, that if you read those Federalist Papers, what they're actually talking about is having a single head of the executive, as opposed to like a council or multiple people in an executive. I don't believe any of them were referring anywhere whatsoever to being immune from criminal prosecution. I think that if you just imagine historically how the United States was founded, the idea of creating an executive who was beyond criminal prosecution is kind of silly. Obviously, none of the framers had this in mind. That would be ridiculous. We just rebelled against the king. Why would we make another one? This means that the burden is on the government to argue that applying a criminal prohibition to that act, or I should say, I'm sorry, that would engage in like a criminal investigation of that act, the government has to argue that that investigation would pose no dangers of intrusion on the authority and functions of the executive branch. There cannot be any danger whatsoever for the president to perform his job. So if you're doing an investigation, even if you think he might have done some criminal act, if that investigation risks damaging his ability to perform any other act, if you can't prove that there would be no risk there, that action is also given immunity. One thing that's important too when we think about this type of immunity that's being granted, this immunity is not like a defense that one would use in court, or it's not a defense that you would use on appeal. This is like a thing that comes before any court action has even happened, right? So we're not even in any part of the court stage. It's not like the president would go to court and would use this as affirmative defense, like self-defense or something. This would be something that would completely prevent all these things from ever even being showed in any trial or anything. Those are official acts. Then the third bucket are things called unofficial acts. These are actions that the president takes essentially as a private citizen. I mean, you can take these actions as president, but they're just unofficial acts that have nothing to do with his job as president. And obviously, Robert says that for unofficial acts, there is no immunity. Now, unfortunately, we are given absolutely no guidance nor examples for what a private act might be or an unofficial act might be. Roberts does not list a single one ever.
Roberts notes that in dividing official from unofficial conduct, courts may not inquire into the president's motives. Such an inquiry would risk exposing even the most obvious instances of official conduct to judicial examination on the mere allegation of improper purpose, thereby intruding on the Article 2 interests that immunity seeks to protect. So when you're doing investigations and you're trying to separate an official act from an unofficial act to figure out was the president operating in his capacity here, for instance, let's say he gives a speech, he could be acting an official act or unofficial. You cannot consider the president's motivations when you're trying to figure out whether or not this would fit the official or unofficial act. A lot of the people that are talking about this opinion are trying to say that, oh, well, he only gets immunity for core powers. That's great. And unofficial acts obviously can still be indictable and can come under judicial review in the criminal justice system. But what all of them are skipping over is the idea that the official acts presumptive immunity could be unfathomably broad, and we've been given absolutely no indication by Roberts, by this court, what those official acts might be. Roberts will go on in his opinion to reference 4 different categories or sections of conduct that are in the indictments against Donald Trump, and he treats each of them as such. So conversations between Donald Trump and his acting attorney general with regards to sending fake letters. He essentially said, he said you need to send letters to states and you need to tell them that we have good reason to believe that there's been voter fraud, that the department is investigating these things and we found evidence of it. He was telling his attorney general, you need to lie and send these letters, and if you don't, I'm going to fire you. Because this is under the exclusive role of the president, these are conclusive and preclusive powers. The president gets to decide, who to fire, who to hire, and it is a core power of the presidency, right, is to choose his officers, and he gets to communicate with his officers about how to carry out their roles. That entire conversation is considered absolutely immune. The quote from Roberts would be readily categorized. So easily, that is an absolutely immune thing. That means that not only is anything that he said in that conversation completely not criminally indictable, it cannot be used as evidence in the furtherance of any other crimes. It's kind of wild, but the conversations between Trump and Pence, with regards to Trump trying to pressure Pence to flip the electoral votes, even the alleged conduct here would be presumptively immune because it is within the roles for the president and the vice president to speak to one another. The only reason why this gets downgraded to at least presumptive immunity is because Congress passes laws with regards to the vice president having oversight over the Congress. So there's some overlap here. Because of that overlap, now the burden is on the government to make the argument that, well, if we do a criminal investigation in regards to this conversation, we have to prove that it wouldn't pose any danger on intrusion on the authority and functions of the executive branch. But because there's some overlap with the federal government's role here, or with the legislature's role here, the argument is that, well, you can try to make the argument that he shouldn't have immunity here, but he's granted presumptive immunity because it falls squarely within, at the very least, the outer perimeter of what it is to perform his role as the executive. So this issue was remanded to the lower courts to try to figure out whether or not they can overcome the presumptive immunity that he's been granted for that conversation. Now, 3 and 4, these buckets of actions that he's talking about. The first is communications with state officials with regards to their electors, calling them and saying like, hey, you guys need to toss your electors, you need to change your votes, we think that there was voter fraud, you need to toss whatever, blah, blah, blah. This was completely remanded to the lower court saying you need to figure out which of these actions were official versus which actions were unofficial. And remember, when they're considering that, they can't take into account his motivations for any of these things. Roberts gave absolutely no guidance for figuring out what was official or unofficial. And then on the 4th point, Trump's speech and actions that he made on January 6th in regards to the ongoing insurrection, that was remanded to the lower courts to figure out which actions here were official or unofficial, with no guidance given for figuring out which ones were official and which ones were unofficial. In the concurring opinion, Amy Coney Barrett writes that she agrees with the core of Roberts' argument that there are probably some core powers that we say should maybe be beyond even criminal judicial review, but Justice Barrett has a much more narrow view of what those powers should be, and she takes an issue with the overly broad view that Roberts has written, essentially saying that, truly, under this official acts bucket, basically anything could be beyond criminal review, depending on how you look at it. Justice Barrett doesn't like the fact that even if you do say something was an official power and is beyond criminal prosecution, that you can't even use these actions in the furtherance of other crimes. One thing I'll say before I get into major point of dissent here is Roberts is doing a lot to balance. He's looking at the trouble of what if the executive is constantly worried about criminal prosecution, and he does this thing over and over again where he's like, we need a vigorous and energetic executive, which is a fair thing to consider. I think that's why in the Fitzgerald case, it's why the court said that, well, you probably shouldn't be able to sue the president for everything because every single citizen in the United States could theoretically be filing civil suits against the president. The one thing I don't like is that Roberts never addresses a single time what about the state or the people's interest of not having a crime-committing president. That is never brought up a single time in all of Roberts' ruling. He only considers the threat of a president having to face criminal prosecution. He never considers the public interest of not having a crime-committing president. There's not a single word addressed to that fear, which is especially frustrating because there are multiple wild scenarios. I think Jackson brings up the idea of poisoning like an officer that you no longer want to work with you, and Sotomayor brings up the SEAL Team 6 example. And despite Roberts addressing some of the dissent, and Roberts addressing even Justice Barrett's concurring opinion, he never ever touches on any of the scarier acts. He doesn't address them at all. I don't know why. It's very annoying. Sotomayor is writing the main dissenting opinion, the larger one, with Kagan and Jackson joining in. And she writes that the immunity is legally and historically inconsistent. She believes that the court is going even further than what Trump's lawyers were asking for, as Trump's lawyers seem to concede that a lot of his conduct was unofficial, and the president might be criminally charged for actions, even if they were official and core powers, as long as he were impeached and convicted first, 2 things that Roberts rejected in his majority opinion. So a lot of people I've noticed, and we'll get into some writing about this, a lot of people are saying that, oh, well, actually, at least the court didn't go as far as what Trump's lawyers wanted. That is not true. Trump's lawyers were saying that, well, if you want to criminally indict a president for official acts, at the very least, you have to impeach him first. You got to impeach him, and then it has to pass the Senate. Roberts rejects that view. Roberts has not said that if you're impeached for a particular thing, that you can now be held criminally liable for it. He says that impeachment clause makes no statement as to what types of crimes can the president be indicted for. So, in my opinion, I would say, and I think some others have said as well, that the court has gone much further in delineating which acts are beyond judicial review and which acts aren't. Sotomayor also points out that there are many federal safeguards in place for criminal prosecution, and that Roberts has failed to engage whatsoever with the idea that the public might have a public interest in having a president who does not feel as though he has any criminal liability while performing his duties. The bias was so strong that the president could never have a fair trial over official conduct. It seems reasonable to believe that he would apply, that this would apply to literally any potential trial involving him, defeating the need for any sort of absolute immunity over any actions at all. Basically, this idea, there's 2 things going on here. One is there's a heavy indictment of our federal, our federal judicial system. The idea that you could have a corrupt prosecutor that would get an approval from a corrupt judge to file a corrupt indictment that he could put in front of a corrupt grand jury who would corruptly approve it, and then you would have all of your pretrial motions would be thrown out for corrupt reasons. The trial itself would be corruptly performed, and then the jury would make, the new jury for this would make a corrupt conviction, and then the upper courts would corruptly not hear any appeals, all the way up to the Supreme Court that would corruptly, like, there's so many safeguards in the federal judicial system when it comes to doing indictments and convictions, and Roberts considers none of those. He says, well, none of that would work because all of this would be corrupt because of the President of the United States. But something that Sotomayor points out, that I think is a good point, is like, if the system is that corrupt, why would we expect this decision to help him anyway? Like, wouldn't you expect to have somebody just randomly indict Trump for just a random murder and just say like, oh, we're just going to indict him for this, we're all going to go after him anyway? It's like, okay, well, if you think it's this corrupt, wouldn't they just convict him on any random thing ever? Like, who cares at that point, right? So she also remarks that it was not right for Roberts to make a determination of absolute immunity for the conversation between Donald Trump and his attorney general while remanding every single other action back to the district court. If Roberts is saying that the Supreme Court is not a court of first review, it's not, the Supreme Court is not in the business of making first reviews or first passes on facts, that's up to the district courts to consider first and then to appeal up to the Supreme Court if necessary, why did Roberts find it necessary to make a determination of absolute immunity over Trump's conversation with the attorney general? Why didn't Roberts remand that back to the court the same way that he did with the conversation between him and Pence, between Trump and Pence? I feel like Roberts should have remanded the Trump and Pence conversation back to the district court, and granted it, he would say, oh, it's probably got presumptive immunity. Same thing with the conversation with him and his attorney general, but he didn't do that. I don't know why he needed to.
Okay, I'm done eating cereal now, so we're good there. He got a point. He got a point. Right? Because what we were reading, we were reading that document, and it was just like, you know, it was basically kicking all that stuff down the road. But he just went ahead and just answered like a few other questions. It's like, shit, if you're already there answering those questions, why not answer the rest of these? That is, yeah, that is true. That is true.
Declaration on one, but he didn't declare anything obviously private or obviously unofficial acts. And then Justice Ketanji Brown, dissenting, writes that while Roberts expresses great concern about the separation of powers that he while Roberts writes a great concern about separation of powers, Roberts obsesses over this idea of separation of powers. Justice Brown points out fairly that the court, in a way, has snatched a huge amount of power for itself because now whatever laws the legislature passes, remember, criminal laws come from Congress. What Congress deems to be crimes are passed in Congress in the form of legislation, and then that goes over to the executive, the president, for enforcement. But the court has said for itself that, Justice Jackson, the court has said now that we're actually going to determine whenever the president is breaking the law, the legislature no longer gets to determine that. Because every single time you charge the president with a crime, obviously the president's going to challenge, well, this is official conduct, you can't probe this, and all of those decisions are going to make their way up to the Supreme Court, most likely, and the Supreme Court is essentially going to have the final say over whether or not a president is ever breaking a crime. So they've snatched that criminal enforcement from the legislature, which one might argue is a more severe form of upsetting the balance of power than simply saying that the president should probably be able to be held criminally liable for their actions. The opinion is pretty unhinged. A lot of people are saying that, people are being unhinged with their evaluation of the opinion. I think people can be unhinged sometimes. I don't think people are being unhinged about this. I think that if we weren't worried about like a Navy SEALs assassination hit jobs on fellow politicians, I don't know why Roberts wouldn't have just addressed that in his ruling. I don't know why Roberts, because Sotomayor brings this up, exactly, saying that like, oh, well, he could order a SEAL team assassination, and Roberts doesn't address that at all. I have no idea why. No opinion tweeted or retweeted this. Basically a thread saying that people were being too hysterical, and then we have a 1 hour Ben Shapiro video on it.
All right, here we go.
This is probably going to come up. I think Tim Poolsbooker reached out to me. I think we're going to do something in a few weeks.
See.
Talk to Michael Knoll soon. I go on his program, I think on the 11th. So I'm pretty sure this question is going to come up quite a bit. So here are like questions I guess that I would have for people that are supporting this decision or think that it's not a big deal. The first.
All right, now let's head down to the lot where Tom Brady is trying to track down our Hertz customer.
I'm here, Vaughn, but looks.
The first question would be, can you give a single example of an action a president might want to take that would be chilled by him being criminally liable, even for the core functions of his office? One assumption that's made is that presidents won't be able to act if they feel like they can be held criminally liable. My counter would be, presidents probably have always felt like they could be held criminally liable. That's why Ford pardoned Nixon. That's why Nixon accepted. Maybe even more importantly, that's why Nixon resigned. I don't think Nixon even dreamed of making this argument like, well, actually, there are some things you can actually never hold me criminally liable for. Even if I'm like obviously working, against my powers or against what the Constitution would want or against the system, like there are probably something you could just never criminally indict me for. I don't think any president has ever operated under that assumption ever. So the idea that like the president might not take some bold action because he's chilled about it being held criminally liable, I'm curious, what actions do you think those are? I really want to know what actions you think the president might need criminal liability to perform to the best of his duties.
Well, I mean, but they wouldn't they just, I think they would just turn to like just his actions, like especially abroad, right? Like especially like with foreign relations, right? What actions a president might want to take that would be chilled by him being criminally liable even for the core functions of his office, right? The assassinations of terrorists is one important one, right? We know, of course, it was always assumed, but the problem is that the court system is going to look at all of it anyway. So hold on. So like, even though like it was never questioned that the president didn't have the authority to do this without being held criminally liable, it's almost like what? It's like I know like people don't like this example, right? Because there is some purpose behind it, but not really, right? Just think of like jaywalking, right? Like jaywalking is illegal. You don't typically hear anybody being prosecuted for it. You don't want people to be prosecuted. You typically don't really want people to be prosecuted for it. It's there because there is a purpose on like not having people just walking through any street in any form of like basically messing up the flow of traffic, especially in heavily populated or high traffic areas. So I mean, you know, like it makes sense and I get it, but you know, you still like it is still something that you could potentially be, oh, that's how you pause? Something you could still be potentially prosecuted for. So like, you know, depending on the actions you take as president, for something that would initially be like, you could say lawfully authorized through the Constitution, so like, you know, terrorist operations, capturing the terrorists and beating the shit out of them, to get like whatever information and secrets you need, you could potentially go to jail for that, right? Or you could potentially held criminally liable for it, but it would be generally understood that you shouldn't be, right? Because I don't think anybody could sit here and say, for example, right, we know torturing people would be out of the question, but like if the president had information to say that this particular American was like a threat, right? They knew of an imminent attack because of a flaw, because of multiple flaws that were inherently discovered that we cannot patch or get ahead of in time, but we can get ahead of the actual action before it happens and like the attack. And this person knows of it. Oh yeah, that man's going into the dark room and he's going to like, yeah, the what is it? The interrogation? Oh yeah, the interrogation gonna get kind of brutal for sure, right? But that interrogation, depending on how it's carried out, could be illegal or unlawful, right? And the president could potentially, if the president authorized it, right, he could be held liable. Now that can no longer be the case. So I think like in for the sake of national security, it's probably like easy to make those examples. I would be interested in seeing like some of the other examples, like the bribery thing. The bribery thing would be a bit hard to kind of justify. I don't know how preventing the president from disclosing like stuff related to bribery, how that would have a chilling effect on his ability to carry out his actions, right? You know, there's just stuff like that. But like law enforcement things, easy. Those kind of things are easy for sure. These new robots, I don't remember seeing these. Self-destructs causing a large explosion. Laser bolts that damage enemy targets or repair allied. Okay, that's cool. I don't think I can get anything else now. Yeah. Cool. Damn, that took so much silicon. Jesus Christ. But yeah, so let me do some initial things, and there's some initial things you could probably say.
The second question would be, if we are so worried about presidents infinitely prosecuting prior presidents for criminal matters, why hasn't this not happened yet, right? Apparently we've seen now that you could always criminally prosecute a prior president. Why hasn't that happened? Again, maybe people are thinking like, oh, well, you know, people have just assumed that's not the case. That's bullshit. Like, source that anywhere. For a court that is so obsessed with textualism and history, where are your historical arguments that it has ever been the case that a president has been assumed to be above criminal prosecution? Even in the Mueller investigation for Trump, which conservatives love to, freak out about all the time, even in that investigation, there were always questions. And I think even Barr, I should have the quotes from Barr. I think Barr's right. Can you indict a sitting president? That was always the question. Can you indict a sitting president? Can you indict? Nobody ever suggested. Well, actually, some people said you can't indict a sitting president. That's not allowed. Nobody suggested, actually, you can never indict a president or ex-president for having committed a crime. At least I don't remember seeing that ever suggested. Like, oh no, actually, presidents are totally unindictable in a criminal sense. The third point here is, why did Ford find it necessary to pardon Nixon, and why did Nixon accept the pardon? The president was assumed immune from criminal prosecution for acts taken as president. I guess I brought that up for the first point. Like, everything that Nixon done, he could have argued was part of his core powers. The people that he communicated with, these were acts of the president. That probing on any of these might
Let's see. Do you think Ben Shapiro has no choice but to vote for Trump due to his media and what he represents in the Daily Wire? It's not that he doesn't have any choice. I think I do think that, like, you're right that because of all of the things that he does represent with his like media company or whatnot, there's a strong inclination to support him, especially when the rest of his staff are like just like all on the Trump train in that regard. But because he has made it clear he dislikes Biden, so that's why, you know, I'm going to be really interested in seeing, like, if, well, I would not to see this actually happen, but if we was to actually have a Trump presidency, I want to know how Trump is going to handle the whole Israel-Hamas thing, for sure, because I feel like whatever determination he makes would not necessarily be in the best interest of Israel, per se. And there's all this pressure on like on ending the Israel war, and Israel has a right to defend itself. So I feel like all that could be like really counter to Israel. So I'd be really curious how he takes that. But thinks Trump is the only Republican Party candidate. I mean, he is the only Republican Party candidate, right? He's the only nominee now, right? Everybody else dropped out. Nobody else is going to come in, because during the debate he was dodged dodging the question the whole time about how he will handle. Yeah, exactly, right. That's what I'm saying. So I'm going to be really curious to see how he handles that the Israeli thing, because I'm pretty sure. I'm pretty sure the decision he makes is not going to be in favor of Israel, not 100% in favor of Israel, per se, right? So we'll see. What do you think of Vivesh? Oh, Vivek. Oh man, that was just all talk stuff. Like the stuff he was saying. Like I think that would be really close to like that question you asked me about anarchism. Like this idea you're gonna the guy didn't like his beliefs. Yeah, like the idea that you was going to dismantle all these different agencies, right? And then you're not going to be clear about like how do you replace all their core functionalities and whatnot. To me, was just kind of like wild. And then didn't he? Because he wasn't the first one to say it, but didn't he jump on the train too on conducting the military operation in in Mexico? I'm pretty sure that's what he. I feel like that's what he did, right? Wasn't it? Let me see here, right? Republican candidates that support military action into Mexico, right? I know it was goddamn DeSantis forced against Mexico. Many Republicans, yeah. So let's see. Was it Vivek too? Jesus Christ. Let's see. Ron DeSantis wants suspected drug smugglers at the U.S. Mexico border to be shot dead. Promises to send American special forces into Mexico, accused Mexican leaders of treating drug cartels as his sugar daddy, and says if he's elected, there will be a new daddy in town. I don't even know what that even means. I just want the statements. Okay, so we know Ron DeSantis. Well, Nikki Haley definitely says she's going to use forces. That's crazy. Shooting people at the border is pretty crazy. Vivek. So you also thought he was just all talk? As far as like not understanding just like what exactly the ramifications for like his decisions, because you don't just go out your way to disassemble like agencies that have been around for like decades before you were even born, to sit there and then all of a sudden say you're going to disassemble them, and then what are you going to have like in their place and how that's actually going to work. And then the thing is that remember they speak of these things as if the timetable for this stuff is going to be really quick, even if you could argue that there is like you could reasonably replace like the FBI, CIA, and all this other stuff, right? This is not something that you're just going to do like at the snap of the finger in like 1 or 2 years. Like just like what's his name, the independent, the guy that's now running independent, because I was watching that Shapiro interview, RFK, when he's like, oh yeah, we're gonna get the blockchain, right, so that we can show all the transactions we're doing in the government, and then we're gonna do this and do that. That sounds like a reasonable argument against the Chevron case, right? Oh, hey, what's going on, Shivingi? That's a reasonable argument against. Well, you're right. So like, as far as the Chevron case goes, like when you make all these, giving the agencies the power to basically like make the laws, that's crazy. I understand that, right? But like outside of that, them carrying out the functionalities of what they're doing, like the FDA, the ATF, all these people, right? That's like that they still have a purpose. They still have a huge public interest in the jobs that they're doing. They shouldn't be the ones creating the rules and regulations to which they make everybody else follow, but they still have a purpose for actually carrying out the stuff that they're supposed to carry out and enforcing the stuff that Congress was originally supposed to pass and the judicial branch was originally supposed to interpret if there's ever a question, right? That the Chevron case should have been thrown out for certain. That I totally agree with. But saying that you're just going to like dismantle all these agencies and not make clear what you're going to have in their place, that's a horrible idea, right? You know what? Think about when Trump kept on saying about dismantling the Affordable Care Act, right? Also known as Obamacare, right? He was speaking all this good ish about having a replacement, and then when it came time to it, right, they were sitting there, they were about to get rid of it without a single replacement at all, period. And I tell you, if there's one pitfall in America, it's healthcare, right? It don't matter like how much stuff you have or like how good you got it. If the wrong thing happens to you and you don't have the right, and you don't have the right health insurance, or you don't have the adequate coverage, you're hoed. Like, you're literally hoed. Like one of the first congressional hearings, I forgot the congressman that says this, right? But during Trump's presidency, either the first or the second Congress we had on the Trump's presidency, right? They said that the very first hearing they had was of a mom whose daughter died because they couldn't afford like the penicillin or whatever medicine it was, right? You know, that is the American dream right there. That is that 100% the American dream right there, where like a medication, right? You can't afford it. Your life depends on it. You're hoed. Period. Like, can it be clear how much magnesium exists in municipal tap water if a judge makes the call? Well, see, and that's the thing, right? The judge isn't going to make the call on that. He's just going to say whether or not like the law actually stated, right? So, like, so the way now it's supposed to be is like, now Congress needs to actually specify all that stuff out, which is not only going to make that entire process a lot longer, but what's also going to end up happening is that some of that stuff just isn't even going to be addressed because it's just going to be in deadlock in Congress, right? Congress says you do this, right? They wasn't clear about that, and then it's got to sit there and re-go through the whole process of the House, Senate, then the president to re-sign or whatever. Like, all of the contentious of stuff that be happening in Congress, this shit ain't gonna get passed. So it's just gonna be stuck in limbo. So whatever law initially gets passed, that's just gonna be what it is, and it's probably gonna be unenforceable. And then it's not gonna be. And the thing is that they're not gonna do anything about it until something drastic happens, where like, oh, you know, there's a whole lot of lead in this, you know, whoever's tap water or whatever, and now all these babies are retarded or something like drastic or crazy that has to happen. That's gonna have to happen before Congress actually acts the way it's supposed to act. But now that whole process is just gonna take longer. This is another good question, but what do you think the American dream is? The American dream, that essentially, so the American dream, like in a nutshell, is supposed to be basically that that if you work hard, you can essentially achieve whatever it is you want and be able to prosper, right? That's my like rough summary of it. That's essentially what it is, meaning that like, as long as you do the right things and you work hard, right, your potential is endless, limitless, and you have nothing to worry about. These things rely on a couple of things to be intact in society, like safety, security, right, and opportunity. Right, you essentially need those things, right? And a lot of that stuff you rely mostly on the government for, right? Opportunity, you kind of have to kind of search for yourself, but at least like safety and security, like those are things you rely on. Because don't you think the American dream is different for everybody? Well, but everybody, at the end of the day, everybody's really looking for some type of like prosperous end, right? Whether you're looking for fame, whether you're looking for fortune, right? Everything is like in some prosperous form for you, right? That could be whatever it is. Life, liberty, and the pursuit of happiness, right? Right? Life is a human right. Liberty is a human right. And then the pursuit of happiness, right, is your own thing that you have to do, that you have to find, right? That is supposed to be, you know, a big component of the American dream, right? And so the thing with that is simply this, okay? Is that if, right, you rely on the government for a lot of this stuff, for the enablement of these things, right? If the government doesn't do it, then you're kind of hoed. So that's what I'm saying. Like, you know, we all rely on the government for a lot of things like safe drinking water, right? I don't want to be able to, like, you know, try to get some water, like whether I'm drinking like a bottled water, it's because I don't drink the tap water. But this is supposed to be the case. You're supposed to be able to drink the tap water and not worry about it. Don't do it. Please don't do it. Don't do it. I can't stress that enough. Don't do it. Like, you're setting yourself up for failure. But I should be able to drink like a bottle of water, right? Or get a store, like some water, or eat food, right? Get food from whatever store, whatever place, and not worry about like some parasite or brain prion that's going to like turn me into a vegetable, right? These are all things that we rely on the government's regulations, the government's ability to enforce those regulations, right? To all be in place so that I can go about my life without worrying that I'm about to get hoed. And then the most important thing is that, and then if the government does a poor job at that, not only do I get initially hoed, but then depending on the situation, it's irrecoverable for me, right? If I get sick to the point where I go to the hospital and the hospital fix me up, but then I get like a $90,000 bill that I obviously can't pay. And then now we're talking before Barack Obama passed the Affordable Care Act, right? So if I got hoed by a huge like hospital bill that I cannot pay, right? Then my credit, right? Because once it hits collections, 90 days, right? Not making a payment hits collections and everything, your credit down the water, right? Now getting housing is harder, right? Because there's credit checks. Getting a job is more harder, right? Because they do credit checks in case if you have excessive debt, right? Because those are certain liabilities that certain companies, especially in certain industries, avoid hiring people to have. Right now, like I can't afford to like start funding certain things. Like if I wanted to start a business and trying to get like an initial credit loan, or trying to like get a new a car or something, right? Like what if my car my car blows up, right? I need a new car, right? I'm not about to finance it if I got a hospital bill that went into collections for damn sure, unless I'm going to pay an outrageous interest rate if I find one that actually gives it to me, right? And then that was one of the things the Affordable Care Act like went into effect that said that those hospital bills shall no longer impact credit, right? Period. I don't know if that's the Affordable Care Act specifically, but around when the Affordable Care Act was passed, like that also went into effect, right? They made like Obama made sure to also throw that into effect as well, right? And all this stuff, right? All those positive things, right? Affordable Care Act, capping out-of-pocket expenses, right? Whereas like, before then, limitless, like how much you'd have to come out of pocket for your expenses, to the point where like, where the insurance company be like, look, your shit's getting a little too expensive. We're not covering it no more. You're 100% on your own on that, right? All that stop, right? All these positive things. And so like, if you're going to say that you're going to remove it, you should probably have something better. You should have something just as good or better, right? You're going to disassemble an agency, you should have something just as good or even better, right? Everything should be covered, right? To sit there and say you're just going to remove something, right, that has all these positive benefits, but then do nothing like he's trying to do with the Affordable Care Act, for example, is crazy. Tap water should be also should be absolutely required nowadays. We have the ability to easily mitigate microorganisms and such in water nowadays. We have the infrastructure. Yes, we do. But we have such poor etiquette in how we manage our infrastructure. I think one comment I remember reading that made me reflect a bit was when a foreigner talked about our subway system, and like he basically said that he understood why the US subway system always looked so trashy compared to like everywhere else. And this was a comment on a video where like somebody had a goddamn trash can. Somebody put a trash can, right, on the train tracks, right, in a subway, and then the train obviously came through, right, and then like all the sparks started flying, and then it shut the whole goddamn like electric system down there, right? How the trash can got there easily placed? Why didn't anybody say anything to like report it up so they could stop the train, get the trash can off? Like I don't know why any of that happened. Why somebody would do something like that? Completely stupid. Apparently they don't do that in other countries. They don't do a lot of things in other countries, and in other countries governments also do a really good job at regulating certain things like chemical usage and whatnot. But with that being said, right, if you're going to replace an agency, have an adequate replacement for all of the needed functionalities that the people rely on, right? Because now, right, if there was any like FDA related protections, right, that the FDA was unrightfully, right, making like rules and regulations interpreting it, all that's out the water. They can't enforce it anymore. So then we're really reliant on companies to not be trying to cut costs, not be trying to cut corners, not trying to do anything shady, and to do what they're supposed to do so that we don't get screwed over, right? You could just look at Boeing. Boeing as a perfect example, right? I don't know how familiar you're watching on the Boeing stuff, right? But Boeing sitting there doing things like using soap water, using regular dish detergent or something to like lube something up, or using an old hotel card to measure something, or like whatever, like random odd BS that they had going on in structuring the safety of their aircrafts, right? That, I want you to picture that with something, well, actually, that's already really bad, because this is a goddamn aircraft. You're gonna have people in the air doing, in the air, like flying in. But like if you start imagining companies taking those type of shortcuts for things like food safety, water safety, right? How they dispose of their chemicals, right? Not dumping it into, whatever waterways or whatever, right? All that stuff's thrown out now. It's all a wrap. It is all a wrap. But yeah, my understanding is that these three goofy goobers here, right, all supported some type of like military operation in Mexico, the one of two countries that we border, that up to this point, there hasn't been like no issue at all, right? We're going to create an issue with one of them, create an opening for like Mexico or whoever to, or Russia or China, whoever, to then make a relationship with them.
The executive to make them fearful in the future of performing other acts. The fourth question I have is, let's say president goes on TV and makes a statement that a particular judicial action would deter him from making tough decisions about running the United States. Would this statement in and of itself not shield him from all criminal prosecution with respect to the judicial action he references, or would it be to the criminal action that he references, as it could then be cited by the court itself as evidence that the proposed judicial action would intrude on the authority and functions of the executive branch? Like, remember, the threshold that the government has to meet when they're trying to prosecute a former president is saying, oh, this won't affect his ability to do his job at all. But what if a president just goes on TV and says, if I get prosecuted for this, by the way, it will affect our ability to do our job? It's like, oh, okay, well, us, I guess, in that case, we can't prosecute. Like, how do you even make that determination? The fifth question would be, would you be okay, this is for conservatives, would you be okay with the entire cases against Joe Biden and his impropriety with Hunter Biden, or anything having to do with Hillary Clinton, assuming, let's say, she was president, falling under the purview of official acts in accordance with this ruling, thereby making all of their actions absolutely immune from criminal prosecution or judicial review? Remember, all Joe or Hillary has to claim is, well, you guys are going to start going through my servers or going through my emails or whatever. Like, I don't even feel like I can operate, without me facing infinite criminal prosecution. I think that Joe Biden could very easily argue that his administration has been hampered by criminal prosecution. Hillary Clinton, if she were president, I mean, she could make the argument like, I didn't even get elected president because of this investigation by the FBI. I feel like Hillary Clinton could strongly make the argument.
You know something? Actually, after Nada's ruling, now Biden can actually sit there and say that, like, if they were sitting there, that whole thing about the pushing the Ukrainian prosecutor out because he was doing investigation stuff, that was official vice president like duties underneath, like empowered by the president. So now now that he is actually president, right? He could sit there and say that, yeah, well, that's just protected, right? Because the president can't be prosecuted, and he was doing his work through the empowerment of the president, therefore it's protected. So yeah, so like that whole Ukrainian thing, whoop, gone. That for sure. I think that argument could most certainly be made for that. The stuff with his son stuff, if it had anything directly related, actually, I think even the son stuff with regard specifically to Ukraine could actually probably be protected. It should be. I think it should be protected. Obviously, Hunter Biden's specific stuff with the gun and the drugs and whatnot, like obviously the president ain't gonna have nothing to do with that. But the stuff with Ukraine, as it involves him as vice president at the time, just because he happened to be there, he could sit there and say, "Oh, that's protected now." All that's protected because he was doing it under the empowerment of the president of the United States, and the president can't be challenged. So, and it can't be inquired upon. Remember, right? The presidential stuff can't be inquired upon. We'll do like another hour and a half of this, and then we're gonna kill it.
That future presidents might be deterred from making certain actions because of potential investigations that could hamper their reelection, right? I think you can very easily make those arguments. And now, so that means any of those actions would be absolutely immune from all criminal prosecution. None of these are even the crazy SEAL Team 6 things. I think that all of these are very easily arguable. I guess we'll see over the coming days if conservatives want to argue over any of them. The first thing that No Opinion cited was this Twitter thread. For everything partisan coded, 80% of people will lie through their teeth to serve their tribe's goals. True. So it'll be hard to find. Okay, and then we have Ben Shapiro's take.
So yesterday, pretty much all hell broke loose. It didn't break loose because of a Supreme Court decision. It broke loose because the left decided, along with the media and Democrats, myself, to lie about the Supreme Court decision in order to revive the flagging hopes and dead body of Joe Biden. Let me begin. At the beginning, yesterday, the Supreme Court released a decision about
now we're actually getting into the
Donald Trump filing a lawsuit to stop the various Jack Smith lawsuits against his claims that as president of the United States, no matter what he did while he was president of the United States, he has full immunity from criminal prosecution. That, of course, is not true. That is a step too far. The idea that the president of the United States is never, for any activity, able to be criminally prosecuted is really silly. If the president of the United States decided that in his home, in the White House, he's going to murder a maid, for example, could he be criminally prosecuted? The answer, of course, is yes.
That's fine that Ben Shapiro says that. We don't know the answer to that, though. We have no guidance on that whatsoever. So this is fabricated from his mind and pulled from nothing.
Step too far. The idea that the president of the United States is never, for any activity, able to be criminally prosecuted is really silly. If the president of the United States decided that in his home, in the White House, he's going to murder a maid, for example, could he be criminally prosecuted? The answer, of course, is yes. However, there is the idea that the president is, in fact, criminally immune from certain activities that a normal person would not be. So, for example, if I authorize somebody to go kill somebody abroad, I'd be criminally liable for that. If I'm president of the United States and as commander-in-chief, I authorize SEAL Team 6 to take out Osama bin Laden, I'm not going to be criminally liable for that.
Okay. Sorry. Wow. Hold on. This is so wrong. I'm sorry. I'm irritated for a few reasons. The president has already understood to have had criminal immunity from these types of criminal charges because the president has been explicitly tasked with the legislature for performing some of these acts. It's either in the official capacity of the president to perform some of these acts, or the legislature has empowered him to through via legislation. We've never, ever, ever needed a Supreme Court to tell us that the president has criminal immunity from that. The idea that we needed this decision today to spell that.
Well, I would sit there and argue that, like, true, we didn't need the Supreme Court, we didn't need the court system period to actually make that clear that the president should enjoy immunity. The problem is it's just that because the law technically, well, prior to then, right, because it technically could be possible, right, if it turned out to be the case. So, like, I tell you what, for example, let's say, right, we know that he has the immunity in, like, killing a terrorist, right? And in doing so, right, he's given a decision to blow up this house, okay? There's a known terrorist in it. But his leadership and everybody around him told him that, look, we don't have a very strong what was it like God, what is the word? What's the word I'm looking for, right? We don't know for certain that this terrorist is in here. It could very well be a bunch of innocent people, right? And so you can either tell us to wait and do further due diligence, or you could have us blow up the house now, right? And again, right, we're only like 20% sure the terrorist is in there, right? It could very well be the case that it's full of, you know, a bunch of like cancer babies, right? It could be full of a bunch of cancer babies, lots of them. And so the president then is like, you know, fuck it. You know, there could be terrorists in there. Let's just blow it up anyway. We'll figure it out later, right? And he does so, right? He's empowered to do that. He's empowered to like, you know, take that action as he's trying to like get the terrorists that are a threat to the you know, the well-being of the United States. However, that in that manner that he just did, that you could say it was probably reckless or disregarded a bunch of like things to ensure that no innocent lives were lost, right? You could have probably made the case that he could have been impeached and then potentially prosecuted for that, for being so reckless and disregarding the possibility of innocent life being there without making sure that those are like terrorist things, right? So now because of the ruling, now that's completely off of the table, period, right? Obviously, this is to say that the president would be acting in a reckless, in whatever reckless manner, right? That in order to make that scenario work, but the fact still stands that it wasn't inherently guaranteed that the president conducting like an official act couldn't have been prosecuted for whatever reason. So you know, I don't know, like that's to me that's a bit of a stretch to sit there and say that we never needed the court to like kind of like make that clear. I think whenever the court has an opportunity to just make it clear that something ought to not be prosecuted, instead of just relying on like good boy behavior from like your trusted bodies. This is how you ended up with Trump. This is exactly how you ended up with Trump, right? You realize that once you had somebody like Trump in the office that would like really stretch the powers that he could stretch the way he did. This is what happens when you try to rely on people just doing what they're supposed to do without making clear rules and regulations on what you can and what you can't do, right? You get outcomes similar to like Trump. So I think the court should definitely try to like clear up as much as it can whenever it can.
Out is entirely inconsistent with the history of the United States. It has never been suggested when Barack Obama joined an American citizen and he consulted, you know, his legal counsel for what was okay with. It has never ever been suggested that the president requires criminal immunity to do his job. That's never been suggested. So the fact that we all that we needed a Supreme Court to tell us this is ridiculous.
If I'm president of the United States and as commander-in-chief, I authorize SEAL Team 6 to take out Osama bin Laden, I'm not going to be criminally liable for that. So there's plenty of stuff that the president of the United States has to be able to do in order to ensure the functioning of the executive authority of the United States. The president does have outsized powers under our Constitution. Those powers are not endless. Immunity is not eternal and endless. That is not the way that immunity works.
We have no guidance on what core powers even are. We've gotten a few from the Constitution, but in terms of like what are the core powers that are exclusive, we don't actually know. There was nothing given. There wasn't a list given by Roberts, and there wasn't even a good way to determine what those are other than this conclusive and preclusive, this idea of what a conclusive and preclusive power is.
President Trump or any other president has endless immunity. The kind of immunity that the dissent in this case suggests. The dissent is written by Justice Sonia Sotomayor, who writes all of her opinions in crayon because she is not an intelligent person and apparently doesn't know how to read the law.
So to be clear, Sotomayor's reading of the law and the underlying Federalist Papers is vastly superior to Roberts. For instance, when Roberts cites over and over and over...
You know what I'm just kind of curious about is like that statement there where he just like sat there and just basically like trashed one of the judges. Like, how do you as somebody, like, granted you might be a lawyer, right? Well, let me just actually take a step back, right? If somebody was a non-lawyer and they was criticizing like how a lawyer was thinking with regards to some like legal you know, some legal problem or issue or whatever, right? I'd feel like you know that should be taken with a little extra due care, because you would expect that the lawyer would be more experienced and more knowledgeable of stuff that you obviously wouldn't be, because you're not an actual attorney. Therefore, right, it just would look a little ridiculous with you saying whatever it is you're saying. And yet him being a lawyer, but it's unclear like if he's actually a I don't think he's a criminal lawyer. I have not ever heard of Ben Shapiro doing any like criminal law work whatsoever, and I don't know if like you necessarily need to be a criminal lawyer in order to let me pause this, if you need to be a criminal lawyer to necessarily be nominated in the Supreme, well, yeah, you definitely don't need to be a criminal lawyer to be nominated in the Supreme Court. But I'm just curious, like how do you sit there and you criticize the thinking process of like somebody who was nominated to be the Supreme Court when you probably had very little, if any, experience doing actual lawyer stuff? I'm just curious. Ben Shapiro, lawyer background. I'm just curious. Let's see. He graduated law school in 2017. It looked like he was admitted to the California bar in that December. Don't stop your rights, but I'm sure, but who is he? And it looked like he's in California, blah, blah, blah. All his wiki page says he worked at a major law firm before stating a legal consultancy firm, whatever that is, as of 2012. But his fourth book was published in 2011, so I think it's safe to say his legal career spanned from 2008 until late 2010, depending on how long it takes for him to churn out his drivel. If his career is limited to under 3 years as an associate at Big Law while also courting a book deal, I'd say no, he was probably not a good lawyer. His subsequent debate skills don't suggest otherwise either. I guess you could say that having really good debate skills was a direct translation to being like a really good lawyer for sure. I wouldn't necessarily say that just the number of years of experience would be a direct determinant on if you're a good lawyer or not. I wouldn't probably like necessarily stake that claim. But if it was really that short of a time, right? If he graduated in 07, was when he graduated the law firm. 8, 9, 10. If he only did three years of law work, then yeah, I would sit there. But then again, like, just because you're not actually practicing law anymore doesn't necessarily mean you're not just like still diving into the things and whatnot. And I think, excuse me, if I'm not mistaken, because if he's still bar certified, isn't there a requirement that they still do? I think don't they do like public, like some kind of public training hours or something like that they have to do in order to like maintain their license and stuff too. So like I wouldn't go as far as to sit there and say that he, like, you know, he's not, he might not be a good lawyer or understand little to if anything about what he sit there to talk about. I just like would definitely have a type of caution that I would apply for somebody, right? For somebody that obviously doesn't actively dive into the weeds per se of like a personal experience into law, to then like sit there and like with such a conviction say that like you know, these Supreme Court judges don't understand law or like whatever it is. To me, that's a bit of a kind of crazy statement to make. But again, that's not necessarily an attack on like his own credentials or anything like that. As I was saying, that just like at the very least, like, you know, you should have something. There's something to kind of like back that up. I mean, they're nominated to the Supreme Court judge by a body, i.e. Congress, right? That is comprised a lot, not exclusively, but a lot of them are like used to be like lawyers or some type of like government official type people, you know? So I don't know.
Again, to Federalist Paper 70 or 77 about this energetic executive over and over and over again. All he's citing to are people talking about why the executive doesn't need to be opposed by, you know, multiple members of the executive. That you should have co-equal executives that are executing the law. None of these citations that Roberts makes ever are alluding to anybody talking about the need for infinite criminal immunity, immunity from criminal charges for the president. So, and Sotomayor's citations, in my opinion, are vastly superior if you read any of the underlying material, which I know people don't like to do. But this idea that Roberts, who cites over and over again to Fitzgerald a case about civil immunity and doesn't make any good or unique or prescient arguments on his own, or the fact that he's citing to a civil immunity case where it seems that every single justice there is also saying like, well, obviously if this was used in the case of criminal immunity, it would be ridiculous, but we're only talking about civil immunity here. The idea that Roberts is writing a more intelligible opinion here is ludicrous. That's just never been a serious consideration.
Out today, as we'll see, claiming that Donald Trump now has the capacity to activate SEAL Team 6 to kill his political opponents. By the way, if Donald Trump had that authority, the current president is Joe Biden, so he could do that to Trump today. I notice that Joe Biden isn't doing that because he doesn't believe this. Because no one believes the claims left are made.
Or because the Democrats act fundamentally differently.
About this particular case.
That's a crazy argument. That's a crazy argument to sit there and say that, well, if all this is true, well, Biden can do it and Biden's not doing it. So obviously that means that Biden doesn't believe it. So obviously this is not this isn't real, right? right? That's a crazy argument that, you know, somebody has the ability to commit a crime, or they think that they have a right to commit a crime, but because this other person that's in the same position doesn't commit the crime, obviously it means that there's no legal justification. There's no plausible legal justification to say that that, you know, other person can commit said crime. That's a really crazy like stretch. That's a really crazy stretch. Yeah, I need to go. I got flying enemies, man. It's pain.
But the actual person being protected here, on this score, would actually be Barack Obama for cloning people like Anwar al-Awlaki. So,
Except you would never be able to convict Obama acting as the commander-in-chief, executing authorities given to the commander-in-chief tasked with like national defense stuff on counsel from his legal department. You would never argue that he had the criminal intent, the criminal state of mind, where you could convict him for the crime of murder.
And you know what's crazy, right? That actually disapproves exactly what Destiny was saying earlier about like it was never needed to be said that, you know, a president couldn't be prosecuted for it, right? Well, now you can see it, right? You can see the scenario where, like, let's say if this thing never happened and then Trump wants to get back in office and go on the vindictive like rampage he would want to do, right? Well, just think about it, right? Now he has control of the Justice Department again. I want to go after Obama for potentially like killing that American citizen. Let's do it, right? He took actions while as like commander-in-chief of the United States. Don't matter, right? You see? So that's what I'm saying. Like, wow, like this was a good thing. This was, in terms of like just hashing out like, hey, like certain things just like as president, he just can't be convicted for. How they went about it and given the blanket immunity, crazy. But to sit there and say that you know, that these things that were assumed that the president couldn't be prosecuted for, without it being like spelled like, you know, clear as day, right? That all of that is just all that's out of the water now. All that's out of the water now. Like now, just like, you know, anybody for whatever reason could sit there and as long as you in some way, shape, or fashion technically violated the law, right? Which you can sit there and say Obama might have done so for killing the American citizen. Of course, obviously the circumstances when you actually dig into it, like it was completely like, you know, fine the on how he had to go about it, right? But that wouldn't have stopped like, you know, some like vindictive persecution. So
It's unbelievable.
here is how this actual decision breaks down. There's an excellent flowchart that was put out by a group called Justice Security, run by Ryan Goodman. And here is sort of how this decision breaks down. So there are effectively two types of conduct the president can participate in. One is official conduct and one is unofficial conduct. So unofficial conduct with the president shipping an intern. Right? That's unofficial conduct. Or lying about shipping an intern. Right? That has nothing to do with the presidency of the United States. That's just the president in his private capacity, basically doing private things that are criminal. So can that person be prosecuted? The answer for unofficial conduct is yes. And so how does that break down in terms of the Trump case? We'll get to in a moment. Then there's the second type of activity, official conduct. Official conduct under the Supreme Court decision breaks down into two categories. One is core, absolute immunity categories. Core official acts. So what would that be? That'd be like pardon power or firing people who work in the executive branch or controlling recognition on the determination of foreign countries. Right? That stuff is like core presidential power. So if the president decided tomorrow to recognize the independent state of Kurdistan, he couldn't be criminally prosecuted for that, for example. He would have absolute immunity.
Or if the president accepted a bribe to recognize the independent state of Kurdistan, he wouldn't be able to be.
The president of the United States is the most powerful person in the country and possibly the world, says Sonia Sotomayor. When he uses his official powers in any way, under the majority's reasoning, he will now be insulated from criminal prosecution. That's not even true. If he uses his powers in improper ways that are outside of his core official position, then a presumptive immunity can be overcome. As I've now
Wrong. If it is a conclusive, conclusive and preclusive power that is a core, it can never be questioned. Doesn't matter how he uses it. That's what absolute immunity is. As soon as you start saying, well, it depends, that's not absolute anymore. So she's talking about the definition for the absolutely immune acts, and those are not questionable regardless of how you use them.
from criminal prosecution. That's not even true. If he uses his powers in improper ways that are outside of his core official position, then a presumptive immunity can be overcome, as I've now explained about 4 times on the show. But since she
Presumptive immunity is only if it falls outside of those conclusive and preclusive powers. That's the
not only that, but like you still gotta, not only that, but you still have to show like if it's something that could allegedly be presumptive, like you still have to show why going after those things wouldn't possibly encroach into his ability to carry out his job officially. So as long as if it's ever the case that something looks like it can be improper, but it's also shows any inkling of being blended in with his ability to carry out any type of official act, it's unquestionable. It's unquestionable. That's the point of the matter, right? The exceptions, right? The exceptions from the limited stuff we read so far, they're not real. They're not real because like the burden to overcome them is damn near impossible. Like I said, I don't see how you can overcome those burdens to say that like this conduct has to show that by prosecuting this, you're not potentially like, scaring the president from being able to take action for like whatever, you know, like whatever job duty or whatever it is that he's like he should be able to do, or he ought to be able to do. Like, to me, that like that's, I don't know. I don't know how, like how. Yeah, I'm gonna put this here. I don't know like how you overcome that. Like that, something like that to me is crazy. So I'd be really the district court's probably like, bro, what the F kind of ish is this? I bet that judge is mad, bro. I bet whatever judge is actually looking at this shit afterwards, bro, he's probably like, bro, what kind of bullshit is this? So, oh gosh, I guess we can go like this. Yeah. Let's go.
Only time this presumptive immunity applies. Otherwise, it's absolute immunity.
Apparently cannot read. Here's what she comes up with Sony Sotomayor, and this is nuts. Okay, this is just nutso, bizarro world, straight from the asylum crap. Here she goes. Orders the Navy's SEAL Team 6 to assassinate a political rival. Immune. Organizing military coup.
He skipped over all of her opinion just to go to the he read her intro, which is going to have the most charged language, by the way, because that's what you do. You're the dissent, and so in the beginning, of course, you're right. This is a sham. That's what you do, and then you make all of your arguments, of which she did, and now you've got like your final paragraph, where she talks about, you know, well, these are the bad things that can happen. He basically read her opening and her ending. He didn't deal with any of the arguments in the middle, really.
To hold on to power, immune. Takes a bribe in exchange for a pardon, immune. Immune. Let the president violate the law. Let him exploit the trappings of his office for personal gain. Let him use his official power for evil ends. Because if he knew that he might one day face liability for breaking the law, he might not be as bold and fearless as we would like him to be. That is the majority's message today. That is, like, every element of that is false. Every element of that is false. Orders Navy SEAL Team 6 to assassinate a political rival. Okay, so the president has a conference. Let's take this to its logical conclusion.
Okay, let's
using
do
the
this.
model
Yes.
that we have set up
Yes.
under the Supreme Court majority.
Yes.
The president does speak to the military. The military does control SEAL Team 6. So that in and of itself is inside the official act. However, the president ordering them to do something blatantly illegal, like murder his political opponent, prosecution of that crime would certainly overcome any presumptive immunity the president has in ordering his political rival to be.
How do you determine something's blatantly illegal? How do you determine something's blatantly illegal, right? If the president is authorized to like kill people under certain circumstances, how do you determine that a particular Clinton is blatantly illegal, right? You would have to figure out the circumstances surrounding about why he killed said person, right? I want to say that's typically what you would have to do. Now, what's the problem, right? The problem is that you can't question his intent or the reason behind what he's doing, because anything private about his decision making on why he decided to take a core constitutional functionality, like i.e. Use the military to do something, right? Or use maybe the agencies to do something, right? It's unquestionable. Period. It's just it's unquestionable. Like we all read it. It's unquestionable. It can't be added or used as evidence. So I don't know what is it that he's trying to say.
He doesn't understand the ruling. Did Harvard stop teaching lawyers how to read law? He's making this mistake, and it was the same one that Connor was making. He's making the mistake that to overcome the presumptive immunity, you have to show that the action was really bad. Let's say that the president orders a thing to execute his opponent or assassinate his opponent, well, we can overcome the presumptive immunity because it's really bad. That's not the test. The test.
Are you a hot sleeper?
What is the test?
Do you find yourself waking up
If I'm not mistaken,
the
the test is that it can't put at risk the president's ability to do his job. Which obviously, like if he does an illegal killing, it puts at risk. Questioning it puts at risk of being able to do his job because he uses killings in order to protect the United States from certain stuff.
However,
so
I have the
test for overcoming presumptive immunity has nothing to do with how bad the act is. The test has to do with if you are allowed to probe on this, will it impede the executive in any way from functioning in the future? That's the test. Nowhere does Robert say, well, if he does a really bad thing, then fine, you can then we can hold him criminally liable. That is not the test. Any actions taken under the official acts are granted presumptive immunity in order to protect the president's ability to execute the duties of his office fearlessly and fairly. This means that the burden is on, quote, the government to argue that applying a criminal prohibition to that act would pose no dangers of intrusion on the authority and function of the executive branch, end quote. Nowhere does Roberts ever suggest that if the action is really bad, then you can criminally prosecute.
Yeah.
That is not the case.
The president ordering them to do something blatantly illegal, like murder his political opponent, prosecution of that crime would certainly overcome any presumptive immunity the president has in ordering his political rival to be killed.
Why? How? In what way? How does that overcome the presumptive immunity? What do you think it means to overcome the presumptive immunity? Sorry.
In fact, if the president were not, in fact, criminally indicted for ordering his political rival to be killed, then that would threaten the constitutional order.
Whoa! Yes! Yes! Holy shit! He unintentionally stumbled upon the incredibly important countervailing interest that Roberts never addresses. That is true. Having a president that could infinitely commit crimes would threaten the constitutional order. Correct. Yes.
Criminally indicted for ordering his political...
I think actually, yeah, hold on. I think somebody check this out. I think Roberts might even explicitly say, Roberts might have even said explicitly that the legality of an action can't even be, it's not even relevant. I'm trying to remember if he said that explicitly or not.
Yeah. He said that. He said that. What you call it? He said that. He said that like just the mere allegation of something being improper, or because it violated some like general law or statute and stuff doesn't matter. Like just because it allegedly violated a law doesn't strip the president of his doesn't strip the core power of the president. Therefore, it's still unquestionable. That is exactly what is said in that statement. I remember this because I wrote it down and I was like, bro, this shit. And I was like, bro, this shit sounds crazy. So hold on.
Oh, here we are. Nor may courts deem an action unofficial merely because it allegedly violates a generally applicable law. For instance, when Fitzgerald contended that his dismissal violated various congressional statutes and thus rendered his discharge outside the perimeter of Nixon's duties, we rejected that contention. Otherwise, presidents would be subject to trial on every allegation that an action was unlawful, depriving immunity of its intended effect.
The top line ruling from the majority of the Supreme Court is this.
So I actually just realized I didn't even realize it was this late. Right? It's almost 4:30 in the morning. And then plus we're almost close to the end of that. That was actually, I ain't gonna lie, that was a little bit, I didn't comment too much on it just because like there actually wasn't necessarily really wasn't necessarily too much into that per se. So I don't know. It's can I just go like this? Oh, if I can just, there we go. And boom, okay. Yep. Put you there.